Number 21, John F. Tinker and Mary Beth Tinker, minors, etc. et al. Petitioners versus Des Moines Independent Community School District et al. Mr. Johnston.
Mr. Chief Justice, may it please the Court. This case is similar in some respects to the decision and the case that resulted in the decision in Epperson versus Arkansas, which the Court decided just this morning. The case is here on certiorari to the United States Circuit Court of Appeals for the Eighth Circuit. One major distinction between Epperson and this case is that this case involves the right of public school students, rather than public school faculty members, to exercise expressions of their opinions in a non-disruptive way in the school. The case began in the United States...
Well, this is not a religious establishment case either.
No, it's not, Your Honor. It's a First Amendment free speech case in the sense of expression of views rather than a worship or establishment case. The case began as a petition for injunction of nominal damages under 42 United States Code 1983 in the United States District Court for the Southern District of Iowa. That court dismissed the petition, and on appeal to the circuit, the decision was split 4-4. The conduct of the students essentially was this: that at Christmas time in 1965, they decided that they would wear small black armbands to express certain views which they had in regard to the war in Vietnam. Specifically, the views were that they mourned the dead of both sides, both civilian and military, in that war, and they supported the proposal that had been made by United States Senator Robert Kennedy that the truce which had been proposed for that war over the Christmas period be made an open-ended or an indefinite truce. This was the purpose that the students gave for wearing the armbands during this period. During the period of time, of course, there were school days, and they wore the armbands to school. Prior to the time when any of these petitioners wore the armbands to school, it came to the attention of the school authorities that perhaps there would be some students who would express views related to the war in Vietnam in this manner during school time. The principals of the secondary schools, the high schools, and perhaps the junior high schools in the city of Des Moines, the public school system, met prior to the time that any of the armbands had been worn and enacted a policy, which was not written but which was agreed upon among themselves, that no student could wear an armband in the Des Moines public school system for this purpose. That if a student came to school wearing the armband, he would be asked to remove it. Failing that, the students' parents would be contacted and their assistance would be solicited in getting the students to remove the armbands. Failing that, the students would be sent home, would be in effect suspended from school until such time as they were willing to return to school without the armbands. The three students who are petitioners in this case, Christopher Eckhardt, who was 16 in the 10th grade at Roosevelt High School in Des Moines at the time, John Tinker, who was 15 and in the 11th grade at another high school, Mary Beth Tinker, who was 13 and in the 8th grade, determined that in spite of the policy that had been announced through the schools that they would wear the armbands as a matter of conscience to express the views that they had. Christopher Eckhardt and Mary Beth Tinker wore theirs on the first day. Mr. Eckhardt went to school, had the armband on, but knowing of the policy against the wearing of the armbands, because as I say it had been announced, he went quite immediately to the office of the principal and said, "I'm wearing the armband. I know that it is in violation of the school policy." The principal carried out the dictates of the policy, which were to tell a student to remove it. The student said he could not in good conscience remove the armband, that he thought he had a right to wear it. The student's mother was called, and she supported her son in the activity. And then young Mr. Eckhardt was suspended from school. He was out of school approximately 6 days, 5 days prior to the Christmas vacation, and then 1 day after the Christmas vacation. Mary Beth Tinker also wore her armband on that first day. However, she wore it throughout the entire morning without any incident related to it that in any way disrupted the school or distracted. She wore it at lunch, and she wore it where there was, by the way, some conversation between herself and other students in the lunchroom about why she was wearing the armband and whether or not she should be wearing it, and then wore it into the first class in the afternoon. And it was in the first class in the afternoon that she was called to the office, and the procedure was followed for contacting her parents, apparently asking her to remove it. And she did remove the armband and then returned to class. However, in spite of the fact that she had removed the armband and was returned to class, she was later called out of class and suspended nevertheless. John Tinker determined that it was his belief that the armband should not be worn in open violation of the policy that the schools had adopted until some attempt had been made to try to reach an accommodation with the school board. So on the first day, John Tinker did not wear the armband to school. Rather, in the evening of the day when Mr. Eckhardt and John's sister, Mary Beth, were suspended from school, he, with some other students who had worn the armbands, attempted to contact the superintendent of the, not the superintendent, excuse me, the chairman of the board of directors of the school, the Des Moines Public Schools, and they requested that he call a special meeting of the board of directors, the school board as we call it, for the purpose of trying to reach an accommodation between the students, the desire of the students, and the policy enacted by the principals of the school. They were refused this special meeting of the school board, and then on the next day, Friday, John Tinker wore his armband to school, wore it throughout the morning hours without any untoward incident, without any substantial or material disruption to the school, wore it at lunch where there was again some discussion about it in a period that's generally free and open for discussion among students, and then wore it into the first class in the afternoon where he was suspended.
What if the student had gotten up in the class he went to and delivered the message orally that his armband was intended to convey and insisted on doing it?
I think in that case...
All during the hour.
Yes, in that case, Your Honor, we would not be here, even if he insisted in doing it only for a second, because he would clearly be, although he would be expressing his views, he would be doing something else.
Why did they wear the armband to the class? To express that message?
To express the message, yes,
To
Your
everybody
Honor.
In the class?
To everyone in the class, yes,
And
Your Honor.
everybody, while they were listening to some other subject matter, was supposed to also be looking at the armband and taking in that message?
Well, to the extent that they would see it, but I don't believe there was any, I don't believe that the...
Well, it wasn't, they were intended to see it, weren't they?
They were intended to see it in a way that would not
And
be
to
distracting.
understand it.
And to understand it,
And
yes,
to
Your Honor.
absorb that message.
And to absorb the message.
While they're studying arithmetic or mathematics, they're supposed to be taking in this message about Vietnam.
Well, except that, Your Honor, I believe that the method that the students chose in this particular instant was specifically designed in such a way that it would not cause that kind of disruption. None of the teachers who testified at the hearing in the district court...
I mean, they were just wearing a meaningless armband.
No, Your Honor, I believe they were...
Carrying an ineffective message and intended it to be ineffective.
No, they intended it to be effective, but at
Why
the same...
didn't they take it off when they went into class?
Well, there would be no reason to take it off when it went into
Because it
class.
was ineffective. Nobody would notice it.
It was not disruptive in the class, Your Honor.
You mean physically, but how about the attention of the students?
Well, there's no testimony by any of the teachers that it was in any way distracting or disruptive.
Why did they wear it again? Why did they wear the armband?
They wore the armband to
convey a message.
Convey the message, that's right.
They anticipated students would see it and understand it and think about it.
That's correct.
And when they did it in class, they intended the students to do it in class.
I think it's as fair an assumption that the method of expression...
They intended the students to think about it outside of class, but not in class.
I think they chose a method of expression, Your Honor, which would not be distracting or disruptive in the class.
It wouldn't make noise, it wouldn't cause a commotion. But don't you think it would cause some people to direct their attention to the armband and the Vietnam War and think about that rather than what they were supposed to be thinking about in the classroom?
I think perhaps, Your Honor, it might for a few moments have done that. And I think it perhaps might have distracted some students, just as many other things do in the classroom, which are allowed from time to time. I think it might...
But which the school is permitted to forbid.
But which the school also allows to continue. I don't think there's any suggestion that the school attempts to regulate all sorts of things that might be distracting, especially in the sense of this type of activity, which probably contributes something to the total atmosphere in the school rather than distracts.
All we have prevents them from wearing armbands any place in the building.
That's correct. That's correct.
It's not limited to the classroom.
That's right. It prohibits them from wearing the armbands at gym class, the cafeteria, in the halls, at any time in school.
Any place within the building.
That's correct.
But your intention is entitled to wear it in the classroom, too, because that's when they were removed from the school.
Well, our contention is that the policy, as it was adopted, that was a broad policy that did not distinguish, not in any way was directed toward disruption or distraction, is a policy which will not stand the test of freedom of expression under the First Amendment.
Suppose it been a big button, stop the bombing.
Well, as a matter of fact, a number of political buttons were worn at this school.
Oh, that is, I'm for Humphrey or I'm for Wallace?
I'm for Humphrey. Well, we didn't have it at that time. I'm for Nixon. I'm for Goldwater. The record also shows that.
Suppose it was just stop the bombing.
I don't believe that. That to me would not be the sort of thing which would be designed to disrupt the class.
Suppose it was a placard with the message. Of course.
The situation, I think, and the problem that we have is this specific regulation directed only toward one specific kind of conduct. Now, there is in the record a document which was Defendant's Exhibit 3 in the trial, which is a broad statement of policy by the school related to things that disrupt, related to disruptive conduct. The difficulty we have with this particular policy, as it was enacted, is that there was no indication, no testimony by teachers, by administrators, or anyone else of any reason to believe that it would be disruptive. And when the students, in fact, did wear the armbands, the record quite clearly shows that it was not, in fact, disruptive. And I believe it's interesting.
Do you think that a narrower regulation that says that you may not wear armbands or buttons or placards in the classroom would be sustainable under the First Amendment?
I believe it would be more easily sustainable were it directed.
Or would it be sustainable?
No, I don't believe so, Your Honor. It would not be.
Do you have to take that position?
Don't have to take that position in this case.
But you do.
No. I do in answer to the court's question because I have to be candid with the court in its question.
Why don't you have to sustain that position in this case?
Well, because the armband regulation in this case was directed toward wearing of the armband at any time in the school, whether or not.
No, but they wore it in class.
Disruptive. They did wear it in class. There's no indication that they were suspended just for wearing it for class. For instance, Christopher Eckhardt.
Well, I know, but why shouldn't the question be were they permitted to be suspended for wearing it in class?
Because the question, I believe, I would suggest that's before us is the question of the policy that was adopted. Whether or not the policy itself will stand the test of freedom of expression under the First Amendment. Christopher Eckhardt, by the way, as I've indicated, never did wear the armband to class and yet was suspended.
Now, the action that was brought was what?
The action that was brought was for an injunction for injunctive relief and for nominal damages under the
against any enforcement of the regulation.
Against any enforcement of the regulation which would infringe upon the students' freedom of expression.
Do you think that your injunction then would forbid them? The injunction you wanted, you think you ought to have, should forbid the school from keeping armbands out of classrooms?
Unless they were kept out of there for the express purpose of preventing disruption, unless there was some showing that they would cause disruption.
Yes, you want the injunction to.
Yes, that's
so,
correct.
And you're trying to sustain that injunction.
I'm trying. Yes.
So you must be arguing that the school may not keep armbands out of classrooms.
On the state of this record.
I suppose you would concede that if it started fistfights or something of that kind and disrupted the school, that the principal could prevent the use of them.
The suggestion I believe we're making, Your Honor, is that there should not be any special rule for freedom of expression cases for schools. Now, that would mean that the general terminio type response, that the state first has an obligation to try to move directly against those causing the disruption, rather than to take away the First Amendment right to free expression, would apply also. But again, we don't reach that in this case because there just simply is not that kind of evidence in the record.
You go to the clear and present danger principle.
Or as the Fifth Circuit in two cases, Burnside versus Byers seems to indicate, and Blackwell versus Issaquena, Byers' case is cited in our brief, a material and substantial disruption to the schools would justify perhaps the subordination of freedom of expression.
Why should the terminal type test be enough to the classroom?
Well, the facts of the terminio case are not necessarily applicable to the classroom, but the kind of test, and the thing, Your Honor, that we've been trying to deal with in this case since the trial is the concept that wholly special rules, wholly special doctrines, for some reason, should be applied to the First Amendment law in schools. What we suggest, and we've admitted from the beginning, that the amount of disruption that's permissible in a public hall in Chicago or in a street in New York, well, anything that prevents the state. No, certainly not. You're talking. I think that's correct. I think that's correct.
So that there could certainly be some whispering going on, or some reciting of the favorite poem, or an undertone altering the classroom. I suppose that's what the young man from class were doing.
Isn't any doubt about that in our mind, Your Honor.
And even though it wasn't disruptive or bothered anybody else at all, I mean, it didn't make anybody mad or anything. This might have made somebody a little amused.
Just might have impaired the ability of the school to carry out the purposes that it was there for.
Well, is there any evidence of that in this record?
Your Honor, there's not. As I say, there was discussion from time to time at the cafeteria at lunch. There was some discussion in the halls. There is, and I'm frank to say, when John Tinker wore the armband in the first hour, they were engaged in a class which was a free discussion type of class. The instructor of the class was outside the room, and he was asked during that period about the armband, and he did explain to the students why he wore it. We are urging upon the court the concept that, especially in the public schools, which as this court recognized this morning in the Arkansas case, and as it has recognized many times before, that it's important that the idea of freedom of dissent and inquiry and expression be maintained in the schools, and that there certainly is nothing in this record which indicates that a sufficient quantum of evidence to overcome that presumption.
As I understand it, and I want to be very clear about this, in response to my brother White's question, if the record showed that the wearing of the armbands significantly or substantially or materially, or whatever's the right word, interfered with the business of the classroom, that is communication between teachers and students, then you would say that disciplinary action would be justified.
I think we can take that position. Now, I would like to make a distinction, if I may, between an expression of an opinion which might itself disrupt the class, and the expression of an opinion which might cause someone else to disrupt the class. And I believe those are perhaps two separate cases. But I'd also like to make a distinction between the expression of an opinion which is coupled with something else, like marching in the hallway, or standing up in the class and making a speech about the war in Vietnam during mathematics class. That kind of thing, I think, the court can prohibit. But we're in a situation here where the record just simply doesn't support that kind of a situation. Rather, it supports the idea that before anyone wore an armband, really on the basis of pure conjecture, that the policy was adopted, frankly, for the purpose, and the administrators and the teachers say this over and over again, it was the principle of the demonstration, the idea of expressing political beliefs that they were opposed to in this context, and that the students were suspended for violating that policy and not suspended for causing any disruption in the classroom.
Suppose a state passed a law applying a ban on black armbands for protest purposes across the board so that it would be applied in private schools as well. Would that be constitutional?
I think that would probably, Your Honor, interfere with some earlier decisions of this court, probably in regard to the right of individuals, of citizens, to establish private schools, and so long as they meet accreditation standards, to educate their children as they see fit. I believe that's probably a different kind of situation from what we have here. The situation here, as I view it, is based not so much upon the conduct of the students, whether or not it was permissible, but the conduct of the state, whether or not the conduct of the state was permissible. Whether or not where we have a situation of pure expression and nothing else, which, with no evidence of any material or substantial disruption of any public interest, whether or not in that situation the state can move to subordinate and to punish freedom of expression.
Why isn't this case moot?
Case is not
Nobody's
moot.
been punished, have they? I'm reading from your brief, the bottom of page 8, top of page 9, showing that the petitioners returned to school at the end of the Christmas vacation, January 4th or 5th, 1966. That's 2.5 years ago, 2 3/4 years ago, without their armbands, and as far as it appears, that's the end of it. They weren't punished for it.
Your Honor, the students each testified in the district court, and this will appear in the record, that although they did return to school because of the obvious dire consequences to themselves if they did not return to school, that they still have these views on the war in Vietnam. They still have a desire to wear armbands to express their opposition to the war in Vietnam, and were the policy taken away, they would wear their armbands to school.
That's in the complaint, is it? Or in the...
It's in the appendix, Your Honor, that testimony in the record. Yes, it is in the complaint, yes.
I didn't see
It's
it.
alleged in the complaint.
I just glanced at the complaint. I didn't find that.
And in any event, because we anticipated the possibility that by the time the case might be finally decided, the students might no longer be in school and might no longer have that interest.
Well, you sued for $1.
That's right, we did, Your Honor. That's what I was getting to.
Isn't the statute require $10,000 to be in controversy?
Not, Your Honor, in a case that goes up under 42 United States Code 1983 rather than under diversity, I don't believe. The statute itself does not name any particular...
Your hope is that these children correctly understood some of our opinions on mootness.
Yes, Your Honor, it is.
I've
also said, well, yes.
What happens if the Vietnam War ends before we decide?
Well, Your Honor, we all hope for that, of course. I would say that the prayer for damages is still there. The students were still out of school for 6 days in the instance of 2, 5 days in the instance of 1. I would also say to the court, speaking very frankly, that my own experience, and I'm sure the court's experience, is that this is not an isolated problem. That the correct balance between the interest of the school in maintaining discipline and decorum and the rights of students who, because I believe of the improvement in American education, are increasingly moved to have opinions and to want to express opinions, that this kind of situation rises and will continue to arise. And we suggest that this case provides a good context for the court to provide guidance for...
This gets the Supreme Court of the United States pretty deep in the trenches of the ordinary day-to-day school discipline.
Your Honor, I really would not think it would get you any further in that sort of thing than did Barnett versus Board of Education of West Virginia, than did the case that the court announced this morning. It did a number of other cases where the court has held that whatever are the delicate functions of school boards, and they are certainly delicate, especially these days, that they still have no function which cannot be exercised within the purview and within the dictates of this court's decision under the First Amendment. And that's really all there is.
No, sir. Yours and establishment case, nothing more.
I understand. Yes.
May I ask you, does it matter what the expression is about? Suppose some child shows up at school wearing an outlandish costume. I don't want to particularize it. And that's in violation of a regulation of the school saying that children must come to school decently clothed. And this child says that I'm wearing this outlandish costume because I want to express a very strong belief that I have in the utmost freedom for the individual. You know, Kool-Aid and electronic test kit and all the things that are being written about these days. Well, this child says, that's what I want to do. Does that make any difference? Does he have a constitutionally protected right with respect to that kind of expression? Or would you limit it to political matters of social and political importance, societal importance, as the older generation conceives it?
Justice Fortas, I believe that the real question in that regard hinges upon whether or not the utterance is expression as contemplated by the First Amendment, which was a finding that the district court made, as a matter of fact, that the students were engaged in the expression of views privileged by the First Amendment unless it's subordinated by some other state interest.
Yes, sir, that's a question. What's your opinion, if you care to express one?
My opinion would be, in that instance, that probably, again, it would depend a lot upon what the student said and the demeanor of the student when he expressed it, things of that sort, that that probably would not be within the purview of the First Amendment. But again, it's just conjecture on my part, and certainly just to wear one's haircut the way he wants to may present 14th Amendment problems as arbitrariness and things of that sort. But it does not present, per se, a First Amendment problem such as we have here.
Mr. Johnston, during the negotiations, was the suggestion ever been made to limit the rule to not wearing the bands in classroom?
Not to my knowledge, Your Honor.
Never was
made.
The board never offered that as a solution, did they?
No, they did not, Your Honor. By the time it got finally to the board, they felt the necessity, I believe, to sustain the action of their principles.
Which school was this?
This was generally the public schools in Des Moines, the 3 schools involved.
Grade.
Mr. Eckhardt was in the 10th grade, Your Honor, at Roosevelt High School. Mr. Tinker was in the 11th grade at North High School, and Mary Beth Tinker was in the 13th grade at Warren Harding Junior High School. No, excuse me, the 8th grade at Warren Harding Junior High School.
Would your principal include the kindergarten?
To the extent, Your Honor, that those people have views and can express them within the purview of the First Amendment, it would, yes. I should not think that there would have to be a special rule for schools or any other part of our society for the First Amendment. Now, the evidence of disruption might be different, but as far as the principles applied, we'd like to have the same principles applied in the school, or perhaps especially in the school, that are applied elsewhere. If I may, Mr. Chief Justice, I would like to reserve the remainder of my argument for rebuttal.
Mr. Herrick.
Mr. Chief Justice and Associate Justices, the respondents believe that there are 2 basic issues involved here. The first, the school administrators or school boards have to wait until violence, disorder, and disruption break out, and the scholarly discipline of the school is disrupted. Or may they act when in good faith, in their reasonable discretion and judgment, disorder and disruption of the scholarly atmosphere of the schoolroom will result unless they act firmly and promptly. The second issue, it seems to me, is that this court must determine how far it wants to go under the constitutional amendments for free speech in reviewing every decision of every school district made in good faith in its reasonable discretion and judgment as necessary to maintain order and a scholarly, disciplined atmosphere within the classroom. A third issue might be added are disturbances or threatened disturbances in the schools to be measured by identical standards with disturbances or threatened disturbances on the streets. Now, it's the position of the respondents that the decision of the school administration and of the school board made in good faith under the circumstances existing when that decision was made was the reasonable exercise of discretion on the part of the school authorities and did not deprive petitioners of their constitutional right of free speech. Now, this court has held that freedom of speech, including, of course, the right of demonstration, is not an absolute right to be exercised regardless of time or place. I'm sure it isn't necessary to quote to this court its own decisions, but the case of Adderley versus the state of Florida seems particularly pertinent, where the students went from the university to the jail grounds to protest the arrest of students who had been arrested the day before. And their claim was...
Mr. Herrick, how many students were involved in the Adderley case?
In the Adderley case?
Several hundred, wasn't it?
It was quite a large number.
How many were involved in this one?
Well, there were, that's a question, Your Honor, of what you mean by involved. There are 18...
How many were wearing armbands?
Well, there were 5 suspended
5
for wearing armbands, Your Honor.
Well, were any wearing armbands who were not suspended?
Yes, I think there were 2.
That makes 7.
They weren't accepted, and I'll refer to that a little later. They were...
7 out of 18,000.
Yes.
And the school board was afraid that 7 students wearing armband would disrupt 18,000.
I think if the court please, that doesn't give us the entire background that builds up to what was existing in the Des Moines schools at the time the armbands were worn. As we view it, the right of freedom of speech, or the right of demonstration in the schoolroom and on the school premises, must be weighed against the right of the school administration to make a decision, which the administration in good faith believed in its discretion was reasonable to preserve order and to avoid disturbance and disruption in the schoolroom.
Been any disruption?
I'll refer to that also, Your Honor. There had been with John Tinker, what I would call disruption. There were 1 or 2 of the boys who had been struck, I believe the record shows.
Well, how many boys are struck in the Des Moines school system per day?
Well,
normally.
If the court please, I think the question there is, and gets back to the first issue that I undertook to state, does the school, if we have an aroused community, have to wait until disruption occurs, or may it act to prevent it?
Well, the school system was aroused. Where is that in the record?
I think I can point that out, if the court please. In the background of this case, in November of 1965, the petitioner, Christopher Eckhardt, with his mother, who was president of the Des Moines chapter of the Women's International League for Peace and Freedom, had come to Washington, D.C. to participate with the Students for Democratic Society, Dr. Spock, and others, in the march, which I'm sure this court's familiar with, from the White House to the Washington Monument. Now, that was in November, I think, about the Thanksgiving holiday. On Saturday, December 11th, 1965, following this march, a group which included students related to the Students for a Democratic Society and some adults met at the Eckhardt home. And one of the proposals that developed this meeting was the wearing of these black armbands. None of these petitioners were present. Now, as the trial court said, and this is on page 73 of the appendix, the last paragraph, the Vietnam War and the involvement of the United States therein has been a subject of a major controversy for some time. When the armband regulation involved herein was promulgated, debate over the Vietnam War had become vehement in many localities. A protest march against the war had recently been held in Washington, D.C. a wave of draft card burning incidents protesting the war had swept the country. At that time, 2 highly publicized draft card burning cases were pending in this court. Both individuals supporting the war and those opposing it were quite vocal in expressing their views. This was demonstrated during the school board's hearing on the armband regulation. And that appears also in the record. I think some 200 had gathered who were, many of them outsiders, at the time of the school board hearing. This hearing, the school board voted in support of the rule prohibiting the wearing of the wearing of armbands in school premises. It is against this background the court must review the reasonableness of the regulation. Now, this is the background that faced the superintendent of schools. This thing had become a matter through the press and through the community, and the superintendent directed Dr. Peterson, who was the director of secondary education, to call a meeting of the principals on December 14th, 1965. And with this background and at this meeting, the principals, in good faith, using their discretion and best judgment, decided that to maintain discipline and avoid disruption, the wearing of the armbands in the schoolroom should not be permitted. Now, on page 46.
Mr. Herrick, suppose they decided to wear black neckties, four-in-hand neckties.
Oh, I would anticipate, Your Honor, there probably wouldn't have been any question about it unless they had built it up to a point where they were...
They used the same build-up, and instead of saying we'll wear black armbands, it said, and in order to mourn the war in Vietnam, we'll wear mourning black ties.
I think, Your Honor, if we get always back to the same problem, whether under the circumstances, it's difficult to sit in this court or to stand in this court and say what faced the schools out in Des Moines in the enactment of this, making this decision against the wearing of armbands. It was an inflammatory matter at that time. Now, Dr. Peterson, the
Mr. Herrick, before you get off that subject,
yes,
is that any different from what was going on in practically every community in this country during the last 2 months during the campaign for the presidency? Weren't those things thoroughly debated and argumentatively and vociferously in almost every community in the country?
Oh, I think that's true, Your Honor, but I think the place for that...
Do you think, then, that what you have read be a sufficient backdrop for stopping First Amendment rights in all of these communities because of that?
I think, Your Honor, that the correct answer to that is free discussion in the classroom is always permitted, always has been, if they want to come in and discuss these matters. But the question of imposing on a captive audience, moving in with an armband when it's known through the press, through the community, through the things that have happened here, that the community is inflamed, might disrupt the orderly conduct of schools.
What did the court have to say, the trial court, as to whether this was an exercise of a First Amendment right?
Well, the court said this.
What page?
It's on page 75. After due consideration, it's the view of the court that the actions of the school officials in this realm should not be limited to those instances where there's been a material or substantial interference with the school discipline.
Now, didn't they say something before that about
Yes.
whether this was a First Amendment right or not?
Yes, I think just
That's what I was
immediately.
interested in.
Here we are. It's on page 72, Your Honor.
72.
Yes. The The question which must now be determined is whether the action of the officials of the defendant's school district forbidding the wearing of armbands on school facilities deprived the plaintiffs of constitutional rights secured by the freedom of speech clause of the First Amendment. An individual's right of free speech is protected against infringement by the due process clause of the 14th Amendment, Gitlow versus New York, 268 U.S. 652. The wearing of an armband for the purpose of expressing certain views is a symbolic act and falls within the protection of the First Amendment free speech clause, West Virginia State Board of Education versus Barnett. However, the protections of that clause are not absolute. The abridgment of speech by state regulation must also always be considered in terms of the object the regulation is attempting to accomplish and the abridgment of speech that actually occurs. In each case, the courts must ask whether the gravity of the evil discounted by its improbability justifies such invasion of free speech as is necessary to avoid danger. Officials of the defendant's school district have the responsibility for maintaining a scholarly, disciplined atmosphere within the classroom. These officials not only have a right, they have an obligation to prevent anything which might be disruptive of such an atmosphere. Unless the actions of school board officials in this connection are unreasonable, the court should not interfere. Now, does that answer what Your Honor had in mind?
Yes, that's what I had in mind.
Now, in this case, counsel has already referred to the fact Christopher Eckhardt went to Roosevelt High School wearing the black armband. He's the one, as I have stated, with his mother had been down here on the march. They come back and they'd had the meeting, at which he didn't attend. Adults held the meeting. When Christopher came to school, he was asked by a student if he knew there was a rule against wearing the armband, and he said he did, and he went directly to the principal's office in defiance of the rule, because, as he said, he thought they might suspend him. Now, Mr. Blackman, who was the vice principal, asked Christopher to remove the armband, and he refused. Now, after considerable discussion, Mr. Blackman finally called Christopher's mother and told her that he would have to suspend Christopher for wearing the armband and refusing to abide by the school's regulation. And Mrs. Eckhardt's reply was that Christopher had a constitutional right to wear the armband. Now, the other two petitioners, John F. Tinker and Mary Beth Tinker, bring this action by their father, the Reverend Leonard Tinker, who is Secretary for Peace and Education of the American Friends Service Committee. And I think it's of some significance here. I don't in any sense feel that it is controlling. If a constitutional right exists, you've got it, period. But Paul Tinker, who's 8 years old, went to school with a black armband on. Hope Tinker, who's 11 years old, went to school with a black armband on. And the petitioner, Mary Beth Tinker, who's 13, went to school with a black armband. John Tinker is 15. He went to school with a black armband. Now, Reverend Tinker testified that he had to support them in what he considered the exercise of their conscience and their own constitutional rights. Now, respondents do not question that the Students for a Democratic Society, or that Reverend Tinker, as the Secretary for Peace and Education of the Friends Society, or Mrs. Eckhardt as the local president of the International League for Peace and Freedom, are entitled to express their views under their constitutional right of free speech. But the point is, not at every time, not at every place. And particularly not under the circumstances that existed in this case, not in the schoolroom, at a time when it might result in disruption and might even result in violence. Now, in substance, if we understand the petitioner's position in this case, it is that the school officials are powerless to act until the disruption occurs. Respondents believe that should not be the rule. Sometimes an ounce of prevention is a lot better than a pound of cure, and I think subsequent history of such activities bear out the judgment of the school officials in their discretion.
On that theory, could they proscribe all discussion or demonstration of interest in political matters or political candidates or issues of government?
Not at all.
In the school?
Not at all. They could prescribe, I think, the classroom and the time and the place where the matters would be discussed. And that...
Suppose they wore a Humphrey or a Nixon or a Wallace button in the school, which might be, as was in many communities, highly controversial, in some places inflammatory.
Well,
could that be done?
I think, if the court please, if it were done as I think the record in this case shows, where they came in with a whole row of buttons on, something of that sort, that it could prove disruptive. It's a matter of dress.
Well, did they come in with a whole row of armbands?
No, but it would be any. Would there be any question if they'd walked in with a placard that said "We protest the Vietnam War"?
I think there would.
Under the circumstance,
don't you think it would be different?
Normally, yes, Your Honor. But I think normally. But I say this: this thing had been extensively exploited in the press. We had a situation here where it was explosive.
Well, now, what evidence is there of explosiveness in the community? That's the thing that I haven't gotten out of this case yet.
If the court please, I refer first, I think, here to the John Tinker for just a moment.
What page?
That would be on page 18 of the appendix. It really starts possibly on the first page. He went to the first two classes. He didn't think the instructors saw it, and he said he sat in the back of the class, I believe, in the second class, which was 10:30 in the forenoon, and he didn't think anybody saw it. And he said, that's the bottom of page 17.
Saw it?
Saw the armband, that's correct, because he sat in the back of the class. Then he went to gym class, and he said that on the way to gym class, there wasn't any discussion. There was hardly no one around. That's the way it stated here. After gym class, some of the students were making fun of me for wearing it. Others, who were my friends, made remarks in the locker room that were not very friendly. Others, who were my friends, said they didn't want me to get in trouble. 2 or 3 boys made remarks in the locker room. I beg your pardon, it was not friendly, I'm repeating. This lasted perhaps 3 or 4 meetings. They did not threaten me with any physical harm. After gym class, I had half an hour for lunch. I ate lunch in the student center with several other students with whom I eat frequently. These people warned me in a friendly manner to take the armband off. There was one student with whom I had had a feud in the 7th grade who was making smart remarks for about 10 minutes. There were 4 or 5 people with him standing, milling around. There were quite a few other students standing and milling around the lunchroom. To my knowledge, there were no threats to hit me or anything like that. At no time was I in fear that they might attack me or hit me in the student center because there were too many people there. Now, it was right after lunch. The exposure, we frankly concede here, on the matter of disruption was very brief, because here Christopher Eckhardt went to the principal's office, and this I have about given you what happened with John Tinker. But he said...
You wouldn't say that anything that happened up to this time, as you have read it, would show any immediate danger of disruption in the school, would you?
I don't know. On, I believe it's page 62.
How about that, though, the question I just asked you?
Well, that's a pretty close question, Your Honor. I don't think this. If the court says there has to be disruption, I don't believe that's the test.
Does it show danger of disruption there?
I feel that it does, Your Honor.
Is that any more than would go on ordinarily
But I feel the test goes one step further than that. In the reasonable judgment of the school administrators and the school board, if in their reasonable judgment disruption were threatened, at that point it's our idea that they are entitled to act.
Yeah.
Without
well, I agree to that, but the reasonableness of it will have to depend upon what is in this record to support it. Isn't that true?
Yes, of course.
Well, that's what I was asking.
Of course it is.
Where is this evidence
on
that shows
page
the danger of disruption?
62, and this is from the deposition of John Tinker.
What page?
62, toward the bottom of the page. I attended the meeting of some 50 people at the building where my father's office, and there are some accounts of some students there as to physical violence had been inflicted upon them over wearing these armbands. Either Bruce Clark or Ross, Bruce Clark was one of the suspended 5, said somebody had struck him.
Is that on 62?
Yes, Your Honor.
What part of the
Well, it says portion of the deposition of John Tinker down below there. I attended the meeting of some 50 people at the building where my father's office, and there were some accounts of some students there as to physical violence that had been inflicted upon them over wearing these armbands. Either Bruce Clark or Ross had said somebody had struck him. It could have been both of them. I was there and recall hearing somebody say that.
Mr. Herrick, would I be correct in assuming that if that violence had occurred in any of the 3 schools in Des Moines, the school officials would have known about it?
I wouldn't want to say that that is true, because I wouldn't know. It depended on how it was brought to their attention.
Would it be normal? And my second question would be, if the school board knew about it, wouldn't they have put in evidence about it?
That would sound reasonable, Your Honor, yes.
Now, what evidence did the school board, the school officials have when they adopted this resolution? Is it on paper anyplace?
No, I think, Your Honor, that
Do we have anything more than your assertion that they used due care and they were reasonable?
I think, as I've stated before, Your Honor, that it was a matter of the explosive situation that existed in the Des Moines schools at the time the regulation was adopted.
And that explosive situation was that they had a meeting in Washington, D.C. What else besides
All
that?
right. This is page 70 at the top of the appendix. A former student of one of our high schools was killed in Vietnam. Some of his friends are still in school. It was felt that if any kind of a demonstration existed, it might evolve into something which would be difficult to control.
Do we have a city in this country that hasn't had someone killed in Vietnam?
No, I think not, Your Honor, but I don't think it would be an explosive situation in most cases. But if someone is going to appear in court with an armband here protesting the thing, that it could be explosive. That's the situation we find
It
ourselves
could
in.
be.
What?
It could be. Is that your position?
Yes, it could
And there
be.
was no evidence that it would be? Is that the rule you want us to adopt?
No, not at all, Your Honor. I think the rule that maybe I can express, I think there's an Arkansas case that I have referred to that expresses what we feel should be the rule, and this is in the Respondent's brief on page 28. And this again was a case where the plaintiff was suspended from school for violating a school rule forbidding the use of face paint and cosmetics. And she brought mandamus to require her admission to school, notwithstanding her refusal to obey the rule.
Did she claim that was symbolic speech?
Well, I can't answer that, Your Honor. It was an expression, certainly.
Well, at least the trial court didn't find that it was the expression of First Amendment rights, as did the court in this case.
What was involved, though, I think, Your Honor, is that it was disruptive of the atmosphere of the schoolroom. And
I'd like to ask you a question, because you seem to have admitted some things that rather bother me. Do I understand that you have admitted the Constitution of the United States forbids the people of a state from borrowing political discussion in their schools if they want to do so?
No, I don't believe I admitted that, Your Honor. I think if the situation broke down the discipline of the school...
I didn't think you intended to.
If I did, I
does the person have any more right to make symbolic speech than he does actually talk and engage in speech which the First Amendment protects? If not, why wouldn't these boys have a right to demand that the school let them talk about Vietnam?
Oh, they would. And it's in the record here that free discussion in school of these matters is permitted.
And what you claim is that you have the right to run your school for the teaching of geometry, history, mathematics, grammar, and the things that people want to teach. And that the federal Constitution doesn't step in and tell you that you've got to let anybody discuss any subject, symbolic or otherwise, if they see fit.
I think so long as it doesn't interrupt or disrupt the
Well, he
atmosphere of the
disrupted,
school.
wouldn't he, if he broke a valid rule?
Yes.
Well, what you're arguing then is whether or not this rule is valid if it's constitutionally protected.
That's correct, Your Honor.
And do you think that the Constitution prevents the schools from borrowing the discussion of particularly acute emotional subjects, such as this is, and allows them to say that we'll have nothing in here except the teaching of the things that the school's for?
I think within reason that's true.
But you wouldn't say, would you, Mr. Herrick, that in doing that they could pick out one particular issue, public issue, and say this you cannot do, but the rest you can do?
I'd go further than that, Your Honor. I would say today maybe the same proposition come up if the atmosphere is different. It should be permitted. My only claim here is that what existed here, that the school administration and the school board acted reasonably and within their discretion. At that time, it could be very different today. Demonstrations at another time that might not be explosive.
Well, do I understand you to be saying now that it's all right for them to interrupt your grammar classes,
No?
your history classes, your mathematics classes, and any other classes that the school's supposed to teach in order to talk about Vietnam?
No, I think that is not correct. If I've given that impression, I'm sorry.
Do you?
No, I don't believe that. I believe the schools are there to give these children an education, and I think Des Moines is one of the bright spots in the nation where they've done it. And I feel that anything that threatens that type of scholarly atmosphere in the classroom ought to be prohibited.
And there wasn't any disruption here, was there?
Well, that's a question.
Well, on page 29, it says the whole period of mathematics on Wednesday was taken up by this discussion of students and demonstration.
That's correct, Your Honor. So they haven't forbade it in the schools, but mathematics, after all, is what ought to be taught in the mathematics class. And I think they're entitled to regulate it. That's what this is a regulation.
Mr. Herrick, I seem to remember in reading the briefs in advance for this argument that there was something here about other students wearing other badges or symbols, but now, in glancing them over, I can't find it except in footnote 2 of Petitioner's brief with respect to some of the students having been seen wearing iron crosses.
I think that's...
Is there anything else?
I think there's
in the record?
Iron crosses. I think sometimes they'd worn political buttons, other things of that sort.
Does that show in the record that you remember?
It does, Your Honor.
It does.
Yes.
What do you do with Myers against Nebraska and Bartels against Iowa?
Well, of course, Myers against Nebraska is the forbidding of teaching the German language, as I recall it.
So is Bartels in substance.
Well,
those were decided in 1923.
Surely. Again, Your Honor, have to come back to the situation that the court really doesn't sit down in the situation that the school administration or the school board does. They've got to say, is this so unreasonable as to violate a constitutional right?
But is that the test you'd really say? That is, the court makes a judgment as to whether it's so unreasonable? And if it is if we think it's so unreasonable, by which I suppose you mean excessively unreasonable, then we say it's a violation of the Due Process Clause of the 14th Amendment, and then we tell the school board what it can or cannot do.
I think we're getting
Is that your argument? I'm asking for your opinion.
My opinion is that if the court undertakes to go that far, you're getting into a very difficult field of trying to say in every instance
I agree with you,
whether a regulation is or is not a violation of constitutional rights. And I think some things have got to be left to the judgment of the administrators.
You'd have to agree with me then, wouldn't you, that Myers and Bartels present very serious obstacles? Because certainly those cases stand for the proposition that denial of that a state law making it a criminal offense not to teach German is unreasonable, and that although that's a state law and state exercise of power over state schools, this court declared that the law is unconstitutional in 1923.
I say this, Your Honor, I think every case must be reviewed on its own facts, and I think that's the difficulty in this court getting into the situation of trying to regulate.
This is a public school, wasn't it?
It is, Your Honor.
Did Myers have something, reservation about public schools? There were private schools in those cases.
That's correct, Your Honor.
Mr. Johnston, you have a few moments to rebut.
Thank you, Your Honor. I would just like to point out, may it please the Court, Mr. Chief Justice, one of the things which I believe has been mentioned but needs to be mentioned more firmly, and that was that there was in this school no general prohibition against political emblems of this nature.
Well, do you deny that under the law of Iowa, the school was acting within the authority of the state law?
The school was acting, Your Honor, under a very broad state statute which gives...
Well, is there any question about that? Do we have to look into that?
No, Your Honor. The question...
We have to accept that as being the law of Iowa.
Yes, I think that's
fair. They were
fair.
engaged in doing what the law gives them the right to do.
Gives them the power to do, yes, Your Honor. But the point I'd like to impress upon the Court this time is that on pages 44 and 50 and 51 of the record, it's very amply stated by respondents that other kinds of political insignia, including the Iron Cross, were worn in these schools, that they were not covered by this policy, that there was no policy covering them. that it was simply this one policy against the wearing of the armbands in this context. Now, counsel indicates that there was some sort of an explosive situation, which made this a special circumstance. I can't, of course, recite to the record to prove the negative. I can just simply say that I don't believe that the record supports that kind of a situation.
Well, if that's a valid rule, it was an explosive situation and a disruption, was it not? If it's a valid rule.
But, yes, Your Honor, it is. But our point is that the rule is not valid.
That's right.
Because it's
Get
based
back to that issue.
Because it's based solely upon a 14th Amendment alone type standard of reasonableness. And this court...
I must say I agree some of the implications my brother pointed about that reasonableness rule. I don't think that case has been cited approvingly in many, many years. And I think the court was very careful to say this morning that it wasn't citing that case to allow it.
Well, for instance, in the case of, in the Barnett case, which we've cited in the brief, which was the case of the compulsory flag salute, this court specifically said that mere 14th Amendment tests of reasonableness are not sufficient in the schools when the students are engaged in something or where the conduct involves something that's privileged under the First Amendment. That's the suggestion we have here. Now, the reasons for the school board establishing the regulation are set out on page 70 of the record at quite some length by a document promulgated by the school board itself. Council referred to them. Those reasons, which were, by the way, passed or at least reduced to paper after the suspensions and a week after the suspensions, simply, to my reading of the decisions of this court, do not provide sufficient grounds for the subordination of freedom of expression. Now,
well, is it your view that your state of Ireland is without power, if it sees fit, to bar political discussions in the school hours where children are being taught?
It would not. It has that power. I believe it has the power, but it's not necessary in this case because that's not what they've done, Your Honor. They've banned only the discussion in one specific instance, and that's all there is. Now
almost an equal protection argument.
Excuse me, Your Honor.
You have something close to an equal protection argument.
In addition to the other argument that I want to make, and I believe the stronger argument is not the equal protection argument, not the censorship by discrimination argument, as Mr. Justice Black has called it. But as a matter of fact, the stronger argument is that the interest that the state sought to protect, whatever that may have been, as set out on page 70 of the record, simply was not sufficient, whereas it might have been sufficient to justify the suppression of something that was not privileged under the First Amendment.
Well, now isn't the real interest that the state's trying to protect is the right of the state authorities and the teachers to run the schools and establish the rules for teaching rather than the pupils. Isn't that the interest it's trying to protect?
Your Honor, I don't read that from the record. I believe from the record that what the school wants.
Which do you think has the most right about controlling the school? The pupils and the policies and teaching? The pupils or the authorities that are running the school?
The authorities that are running the schools under the authority given by them by the Constitution of the United States and within the provisions of that Constitution. And the whole nub of our case is that they've exceeded their powers under that. Thank you.